Good evening, everyone. Thank you for having signed up, and welcome to the first English language conference of the Mergers and Acquisitions Research Group at the Universidad de Los Andes. My name is Daniel Carreño. I'm a senior member of the group, and alongside Natalia Bocanegra, I will be moderating today's talk. Today, we have the honor of welcoming Professor Wei-Ji Wang. Professor Wang is an associate dean and professor at the City University of Hong Kong School of Law. Prior to joining academia in 2005, she was partnered at Allen and Gledhill Hill in Singapore, where she practiced in mergers and acquisitions and equity capital markets. Her main areas of research are corporate law, M&A, securities regulation, and global restructuring and insolvency. And her publications have appeared in some of the most important international peer-reviewed law journals. In this conference, we will be discussing hostile and mandatory takeovers in Asia, a topic that has gained significant importance in the region in recent years. We are really excited to have Professor Wang with us today to share her knowledge and expertise on the subject.
Well, good evening to everyone. My name is Natalia Bocanegra. I am a member of the Merger and Acquisitions Research Group from Los Andes University in Bogotá, Colombia. First of all, I would like to thank Wei-Ji Wang for taking the time to be part of this important event. And also thank you to everyone who joined tonight. This evening, Professor Wei-Ji Wang will be presenting a comparative analysis on the adoption of the mandatory bid rule and its variants, giving the jurisdictional divergence in terms of structural, legal, and institutional foundations in 6 significant Asian countries. If you have any questions throughout the entire presentation, you can leave it in the chat box and we will be reading it out loud at the end, or you can ask them directly also at the end. So without further ado, please welcome Professor Wang.
Thank you. Thank you to the research group for mergers and acquisitions at the University of Los Andes. And I also particularly like to thank Daniel Carreño for the invitation to be able to give a Zoom lecture on the comparative takeover regulation in Asia. So I'll be looking at mandatory bid rule and hostile takeovers. So as Daniel mentioned, I'm a professor of law at City University of Hong Kong. I'm a Singaporean by descent. I am currently working in Hong Kong. And before I was with the City University of Hong Kong, I was with Singapore Management University. So now, for takeover developments. So and when I got the invitation and to be able to give this Zoom lecture, so I was looking at the developments that are happening in Colombia, and I see in particular that there is a litigation involving the billionaire Jamie Gilinski in relation to the bid that he's making for 3 of the most important companies on the stock exchange. And he's trying to unlock the complex shareholdings, which will actually give him control over basically more than half of Colombia's stock market. So when we look at Asia, we see less of the complex intertwining shareholdings, but it is also characterized by a series of very concentrated shareholdings among particular business families, and in certain cases, the state. So what I hope to do today is that I will touch on 6 economically significant jurisdictions in Asia. And there is a mix of both common law and civil law. Common law, I'll be focusing on India, Singapore, and Hong Kong. As for civil law, I'll focus on China, mainland China, Japan, and Korea. And through what I see to be some of the more fascinating aspects of takeover regulation, and hopefully that would be, I think, relevant to what is happening in Latin America. Okay, so what I'm going to do is that I divide an hour or so in the following way. I'll give an introduction. I'll explain the mandatory bid rule, and I'll explain the hostile takeover regulation. And then finally, I'll conclude with the implications and conclusion. The slides will be made available to the participants of this lecture. The work that I'm presenting today is based on 2 papers. The first paper is with my colleague at National University of Singapore, Umakan Barotil. He is also has a long he has a career in practicing corporate law in India. So the first paper would be on the divergent designs of mandatory takeovers in Asia, and that has been published in the Vanderbilt Journal of Transnational Law. The second paper, which I will also be discussing, would be on the hostile takeover regimes in Asia, again with Umakan Barotil, and this is published in the 2019 Berkeley Business Law Journal. So now, so in terms of the background, so let me explain what the key characteristic is in relation to the listed companies in Asia. There's a high concentration of the shareholdings. The details as to how concentrated the shareholdings are is, well, we don't have very updated data, but based on, I think what one of the data points that we have by Carney and Chow, and I don't think it's debated very much since 2008, and I'll explain why, is that Japan has the largest number of widely held companies, about 57.4%, Korea is 28.9%, Singapore and Hong Kong at a dismal 8.4% and 6.3% respectively. For widely held companies in India, we look at the CNX 100, which is the top 100 companies listed on the Indian stock exchanges, is 16% only. And in China, the average concentration is about the 33%. So given this kind of background on the high concentration of shareholding, it does suggest that when we look at how we look at hostile takeovers and how we look at the mandatory bid rule, we are dealing with a lot of difficulties in trying to do hostile takeovers, and whether the mandatory bid rule actually makes a lot of sense. Now, having said that, even though there's a high concentration of of controlling shareholders, there are many cases in which you have more than one significant shareholder. So you have 2 or 3 significant shareholders. They do not control the majority of the shares, but they control a significant proportion of the shares, and they are also the largest shareholders. And we also see in some of these cases, we get to see hostile takeovers as well. So this is the background in relation to the shareholding structure in the listed companies. So I will start with the mandatory bid rule. The mandatory bid rule is really a rule as to how we want to change control. So I start with explaining the 2 models of the mandatory the rules on change of control in the US and the UK. Both countries exhibit divergent designs on how we regulate change of control. In the case of the US, it operates the market rule, which is that there is essentially very little restriction in acquiring shares of a publicly listed company. But in contrast, you have the mandatory bid rule, which is found in the UK. In the mandatory bid rule, once the acquirer acquires or builds up the shareholding, which amounts to 30% or more, the acquirer and its concert parties would be required to make a takeover bid for the remaining of the shares of the company. In a mandatory bid rule, the key would be as follows. The acquirer has to make a mandatory bid. There are requirements as to what the bid entails. There is a minimum price on which the bid has to be made. And there's also the requirement that the control premium be shared among all the shareholders. So with this divergence in the approach towards change of control, what is the objective and effect of the MBR or the mandatory bid rule? So there are several benefits which have been documented in the literature. One is that it enables the minority shareholders to exit at a fair price. You can exit because if they don't like the new shareholder coming in who has acquired 30% or more of the shares, the minority shareholders can then sell out to the bidder and exit at a fair price. The second benefit is the sharing of the control premium. So the acquirer must make a bid for the shares at a minimum price. The minimum price is not less than the price at which control is obtained during the takeover offer and 6 months before. So in which case a premium has to be shared. The mandatory bid rule originated in the UK. Now, when we look at the two countries here, US and the UK, both of which are characterized by dispersed shareholding. So in both countries, among the listed companies, largely dispersed shareholding. So in which case the mandatory bid rule was conceptualized in that respect. You want to enable the minority shareholders to exit at a fair price. However, the mandatory bid rule also has costs. What are the costs? The cost would be that because you make it more expensive for the acquirer to make a bid for the listed company, you make it more expensive the bidder or the acquirer would then have to end up making a mandatory bid for the remaining shares. So this means that there will be situations where the acquirer can potentially see value in the synergies and the combined efficiencies of the merger or the takeover, but will hesitate to do so because this will mean that the bidder would have to actually mop up the shares of the rest of the shareholders. So this may deter value enhancing bids. So that's the cost of the MBR. So in the Asian context, interestingly, all of the 6 significant jurisdictions in Asia have adopted the MBR in one form or another. But however, the adoption has been one of what I will call a spectrum. Some jurisdictions adopted the UK MBR in its entirety, that's Singapore and Hong Kong. The other jurisdictions, China, and in this lecture, when I talk about China, I refer to mainland China. So China, Japan, Korea, India, they adopted some form of the MBR, but they also used the US influence of the market rule. So let me explain what it means in the later slides. But there is no one size fits all because we can see the divergent approaches towards the adoption of the MBR. So MBR is the cornerstone of takeover regulation, and each jurisdiction develops the rule in a way that suits the needs so it falls somewhere between the MBR and the market rule. So I look at China's history with the mandatory bid rule. At first, in 1993, it adopted the UK MBR in its entirety. So this is what we call the strong form of the MBR. Once the acquirer reaches or has acquired 30% or more of the shares, then the MBR is triggered. In the subsequent years, when the Chinese state-owned enterprises start to raise funds in Hong Kong, the Hong Kong follows the UK MBR, the strict version of the UK mandatory bid rule. So when a lot of the Chinese SOEs began to raise funds in Hong Kong, the senior management begins to understand how the MBR operates. And also experts in Hong Kong have advised the Chinese legislators on the MBR. So the MBR was taken to be the default rule in China. The trigger sets at 30%, similar to the UK. However, in spite of the introduction of the MBR, there were not actually many mandatory offers in the early years. There are several reasons for the situation. One of which has been identified by the academic scholars, is that the regulator, the China Securities Regulatory Commission, or the CSRC, possesses discretion to grant exemptions. And therefore, when the exemptions are granted, you can have shifts of control without having a mandatory bid. The 2006 takeover measures were introduced. And with the introduction of the 2006 takeover measures, it embraced the idea of partial offers. So the current regime, you have 3 types of offers. The first is that if you hold less than 30%, you can make a partial offer for not less than 5%. If you hold between 30 and 50%, you can make a partial offer for a minimum of 5%. And in either case, pro rata acceptances of over tendering. So, and if an acquirer holds less than 30% and wishes to acquire shares privately, that will lead to the threshold being breached. Only then the offer must be made to all shareholders. So this is the only situation where you need to make a mandatory bid, similar to what you see in the UK. Now, another concept which China has used is creeping acquisitions. The creeping acquisitions has been abolished in the UK. Essentially, what creeping acquisitions means is that if you hold more than 30%, you can still slowly increase your shareholdings. You will not trip the mandatory bid rule so long as you acquire a small percentage over a certain period. So UK has already abolished that, but China has continued to adopt that, which is that if you hold more than 30%, you can hold not more than 2% over a 12-month period. So what you can do is that you can slowly build up your position without having to make a bid, but you must do it not more than 2% over a 12-month period. So China began with the UK-style MBR, but has deviated substantially. And in actual practice, the mandatory offer is the exception rather than the norm. So Japan has introduced the MBR in 1990. It applies if you acquire not more than 1/3 of the shares in the target. That was in the 1990 position. It allows partial offers so long as it's kept at 2/3 of the target shares. And the MBR is triggered only through private acquisitions. It's not triggered through market purchases. So unlike the UK's MBR, there is no full exit. There's no full exit because the bidder can make a partial offer. And the goal is actually one of transparency and not exit. Why transparency? Because the MBR is only triggered through private acquisitions. If you acquire it off market, so it doesn't show on the dealer screens, that's a private acquisition, and that's where you trigger the MBR, but not if it's a market purchase. The 2006 amendment to the Securities and Exchange Act provides that if you acquire 2/3 of the shares, you then trigger a full offer. So 2/3 is actually a quite high threshold. This is more than the majority. The reason is that fundamental corporate decisions will require 2/3 shareholder vote, but arguably is quite redundant because the bidder already has control by then. Korea has a more unusual path regarding the MBR. The MBR was the law since the 1970s. An acquirer wishing to acquire more than 5% of market from 10 shareholders or more during a 6-month window, in such a case, it would be required to make the MBR. So it's done by way of a tender offer. So there are some differences from the MBR. The first is that the trigger for the offer is not to do with de facto control. The trigger is that if you acquire more than 5% is an off market. So it's more of a transparency rule. It only applies to stock market transactions, doesn't affect acquisition in the securities market. And the focus is on partial offers, which are implemented through pro rata acceptances. So the time where I introduced the MBR is 1997. Now, the timing is also not the most ideal because 1997 was the beginning of the Asian financial crisis. For those of us who have lived through the Asian financial crisis, the lessons will never be forgotten. That was a time of, I think it affected the Asian economies a lot more than the global financial crisis of 2008. So the Asian financial crisis happened at the onset of towards the end of 1997 and lasted all the way to 1999. But in Korea, the MBR was introduced in 1997. So in 1997, if you acquire more than 25%, you then must make a bid to acquire at least 50% of the shares. But it was only a short-lived rule because with the onset of the Asian financial crisis, Korea was in a bad shape, and the IMF, the International Monetary Fund, and the World Bank, when they provided rescues, they demanded a financing conditions. The IMF and the World Bank required the Korean economy to be open to acquisitions by foreign firms. The MBR was regarded as an impediment towards such acquisitions because the MBR prevented hostile takeovers, but also friendly ones too, because it makes it quite expensive for the bidders to actually undergo takeovers. There were also calls to ensure similarity with the US approach towards takeover regulation. So MBR was abolished after a year. And currently, there is no momentum to reintroduce the MBR. The 5% tender offer rule still continues, but it makes Korea an outlier among the Asian jurisdictions. So now I go to India. So India, this is the next three jurisdictions I will discuss, the common law Asia. So India, the MBR was shaped largely by the Securities and Exchange Board of India over the years. Originally started with 10%, later to 15% and now 25%. But it allows for partial offer for not less than 26% if you want to acquire legal control. Now, the MBR in India is a little bit unique because unlike the UK, which you acquire a certain threshold of shares, you trigger the MBR. The MBR can be triggered even without the acquisition of 25% shares. If in these circumstances happen, you have a right to appoint a majority of the directors. You have control over the management and policy decisions of the target, whether directly or indirectly, or you have, by virtue of your shareholding or management rights, or shareholders' agreements or voting rights, you have such control. So it allows for creeping acquisition. If you hold between 25 and 75% of the shares, you can acquire up to 5% each financial year, which is a comparatively generous limit. And the incumbent can gradually consolidate control without ultimately invoking the MBR. So Hong Kong and Singapore, the story is less interesting. It has followed the UK strong form of the MBR. The trigger is set at 30%. And once the MBR is triggered, the bidder must make a full offer for all of the shares. And partial offers are generally looked down upon. They allowed creeping acquisition, unlike the UK, which is abolished. So if you acquire more than 30%, if you hold more than 30%, you can acquire no more than 2% over a 12-month period in Hong Kong or 1% over a 6-month period. Barring the creeping acquisitions, the regimes are largely similar to that you find in the UK. So overall, we can find the divergence from the UK-US origins, and there is some variation among the Asian jurisdictions themselves. But except for Singapore and Hong Kong, the MBR has actually been diluted substantially, making them the weaker forms of the rules. So what are the main issues that we see in the forms of dilution? So 5 of them. The first is the trigger threshold. Second is the partial offer. The third is pricing considerations. Fourth, creeping acquisitions. And fifth, exemptions. So trigger threshold. So in the Asian jurisdictions, the MBR, they range from 25% to 1/3. Now, a high percentage provides limited benefit to minority shareholders because if it is a very high percentage, then in which case you can't get your exit. So if we look at Japan, for example, if it's a high threshold, you can't really get your exit. But if you peg the percentage as being too low, you have the converse impact, which is that you will inhibit changes in the shareholding or changes in control. So the natural proposition when we look at it is that when your shareholding is dispersed, it makes sense to have a lower threshold. So in the UK, when the shareholding is largely dispersed, it makes sense to have a lower threshold. And when your shareholding is concentrated, it makes sense to have a higher threshold. So in Asian jurisdictions, if you have a too premature trigger, it prevents efficient control shifts, and it potentially actually diminishes the value of the rule on the market for corporate control. So when we look at it and we see the UK, the UK's MBR was set at the time when the shareholding is dispersed. But yet, the Asian jurisdictions have followed the rule in one form or the other, even when the shareholding is concentrated. Now, partial offers. So partial offers is a variation. It is allowed in the UK as an exception to the MBR, but is only in very limited circumstances. So the partial offers is a exception to the MBR because the bidder is allowed to acquire part of the shares, even when there's a change in control. There is no need to acquire all of the shares. And so the acquirer is not required to basically pay the full premium. Now, partial offers are very limited in the UK, but they're the norm in China, Japan, South Korea, and India. So India is the most liberal. You can have partial offers, both ex post and ex ante. Ex post means once you cross the MBR, you don't have to make a full offer. The acquirer can make a partial offer. So the selling controlling shareholder can sell to the acquirer in a private arrangement, but you don't have to share the premium with the other shareholders. For China, Japan, and Korea, once you increase the stake that crosses the MBR, you must make an offer to all the shareholders, but this can include a partial offer. So you cannot cross the MBR threshold by buying the shares privately. So controllers can only sell the shares by participating in the partial offer and cannot then ensure the sale of all their shares. Singapore and Hong Kong follow the UK approach, which is that partial offer is possible, but only in the form of voluntary offer. So it is not possible to do a partial offer once you trigger the mandatory offer. And in terms of the restrictions, there are many. It's similar to the UK. You need prior approval of the regulator to do a partial bid. You need the whitewash waiver. Whitewash waiver happens when you must separately get the approval of the shareholders to waive the mandatory bid. So you cannot acquire shares during the offer period and the 6-month period before. So pricing considerations are also important. Under the strong form of the MBR, the bidder must make a minimum price that is equal to the highest price paid during the offer and usually 6 months before. But they don't necessarily have to follow, in Asia, they don't have to follow the minimum price rule, which then dilutes the rigor of the MBR. So in Japan and Korea, the bidder can set the price. In China, the CSRC, that's the regulator, requires the minimum price that is the highest price that the bidder has purchased during the 6-month period before the offer. And if it's less than the average price during the 30 days period, the financial advisor must opine on the fairness. The problem is that if you rely on the financial advisor, sometimes they are not effective safeguards because there are several ways you can circumvent the MBR. So on creeping acquisitions, that allows the controlling shareholders to consolidate control without having to make a bid, which has been abolished in the UK, but it makes it more generous to the controllers. It's allowed in Hong Kong and Singapore, as well as India and China. So what does that mean for creeping acquisitions? It also drives the way that you do your IPOs, because if the controlling shareholders at the time of IPO decides that it is how many shares that the controlling shareholders wants to retain, it is possible for the controlling shareholders to retain, say, just slightly over 30%. And later on, the controlling shareholder may decide to slowly get back control. So there's that flexibility for the controlling shareholders to be able to do that without having to trip the MBR. Now, what are the exemptions to the MBR? In the UK style, which is a strong form of the MBR, there are very few exceptions. The exceptions happen when you transfer within the same group, when you have a whitewash waiver, i.e. if the shareholders actually waive their rights to of the mandatory bid, and only the independent shareholders can vote. This only happens also in the issuance of the new shares. But outside Hong Kong and Singapore, the Asian jurisdictions apply the exemptions quite liberally. So in China, there is a very high number of waivers which are granted by the CSRC during 2003-2007. After 2006, the exemptions continue, and exemptions include if you have no change in control, then there's an all-catch-all. which is that any circumstance recognized for adapting to developmental changes of the securities market or protecting the rights and interests of the investors. Bearing in mind that these are administrative decisions which are made by the regulator, often you don't get see the reasons, and actually exemptions are granted in the vast majority of the cases. So in India, the exemptions constitute 57% of the bids. So that also is a very high number of exemptions that are granted from the MBR. So the outcome of the MBR. So if we look at the goals of takeover regulation, you want to promote efficient change in corporate control. You want to stop or at least reduce inefficient changes. The MBR in the UK and the market in the US attempt to achieve the goal through these methods. The 6 jurisdictions, they don't adopt either approach wholesale, but they modify to make some hybrid approaches. Okay, so I will now go on to hostile takeovers. Again, in hostile takeovers, in terms of the regulation, there is a divergence in how the US and the UK approach hostile takeovers. So in the US, the board can say no to a hostile bid. Now, I'm generalizing here because the case law is quite complex, but basically, after the Unicao decision, the board, it's possible for the board to say no in the face of a bid which is not supported by the directors. However, the board can say no if the board believes that the bid undervalues the targets, and the board believes that it is possible that in the long term that you can get better value. However, if the board has decided that the company must be sold under the Revlon test, the board then has to sell it to the highest bidder. In the case of the UK, the decision lies entirely on the shareholders. The board is neutral and is required to be neutral. So in other words, the board cannot say no to a hostile bid. The entire decision must be made by the shareholders. So there is a divergent approach towards the regulation of hostile takeovers. Now, what are the objectives and the effects of the rule? So if we look at the US approach where the board can say no, of course, the board has to say yes in certain circumstances. That is when you want to sell to the highest bidder. When you have decided to sell, you must sell to the highest bidder. But if the board can also decide that no, because we can get more value for the shareholders in the long term. So the benefits are that twofold. One is that you can take into account the interests of a wider variety of stakeholders, not just shareholders. So the argument has been that you can take into account the long-term interests of your customers, your employees, which would otherwise not be possible in the UK style of regulation. In the UK style of regulation, the criticism has been that we only look after the shareholders. So with the effect that even if it leads to actually prejudice to the wider stakeholders, such as the employees. In the more recent scholarship, the advantage again of the rule of the board that can say no is that the board can take into account a long-term view of the future of the direction of the company, and of course also environmental and social responsibility and governance issues, the ESG issues. Now, of course, such a rule has its own cost. The cost being that if the board says no and is able to erect defenses against the bidder, that cost will be in the form that it will be more difficult for the bidder to actually make the bids, and therefore it will inhibit efficient changes of control. In the UK context, because the board has to stay neutral, so effectively what the bidder is only looking at one issue, which is how much value you can give to the shareholders. So either approach has its own benefits, but it also has costs. So how do we disseminate the rules on hostile takeovers in the Asia? So common law Asia, India, Hong Kong, and Singapore, in theory, they adopt the strict board neutrality rule, which is that the shareholders will decide. Now, in the UK style of the takeovers, the bids are all governed by the code, the takeover code. So under the takeover code, one core principle is that the board is to remain neutral and let shareholders decide on the outcome of the bid. The regulator also plays an important role because the regulator if there are disputes, the regulator will make a decision, and much of the takeover disputes are not adjudicated before the courts. They come before the regulator is decided by the regulator, by the takeover regulator. So if we contrast that to civil law Asia, which is China, Japan, and Korea, they have adopted the US, more specifically the deliberate approach, where the courts determine the outcome of the disputes through operation of the fiduciary duties. So that has been the approach. Now, one question that arises is that do we have hostile takeovers in Asia? Now, even though there is the dominance of concentrated ownership structures, the hostile takeovers do happen, usually in two situations. One involves your widely held companies, and the second one involves where you have more than one significant shareholder, but the significant shareholder does not have majority control. So in such a case where there's a dispute, then one of the significant shareholders may actually want to make a bid for the target. So now in the paper, the full paper, we argue that a lot of the reasons for the regulation as to how it looks like also deals with the process of takeover regulation as to how we adjudicate or takeover disputes. By using a regulator to determine the outcome of the disputes versus using the courts to determine the outcome of the disputes. So the reason why we think that it makes a difference is because for civil law Asia, when you have a board neutrality rule, we call that hybrid board neutrality rule because the rule only applies when the takeover offer is announced. So the board is only required to be neutral when the takeover offer is announced, but the board can preserve its own position. It can erect defenses before or in anticipation of the takeover attempt, which was done, for example, in China for the contested bids for Vanke in 2015. The Japan and Korea do not have a similar board neutrality rule, so the boards can actually announce or decide to have to erect defenses. So how does the courts police the behavior of the directors? It is through fiduciary duties. So in Japan, especially after the Livedoor case in 2005, the takeover guidelines which were promulgated allow for any pre-bid defenses, including any pre-warning rights plans. In a later development in Tokyo Kikai case, the Supreme Court of Japan upheld a poison pill that was approved of the basis of the majority of the minority shareholders. Korea has a proper business purpose test to enable the boards to issue shares in a hostile takeover as a mode of defense. The question that we have raised and we discussed in a greater length in the paper was by using fiduciary duties. Now, fiduciary duties is also similar and has been used in the US context when discussing whether the boards can actually erect defenses against hostile takeover to prevent hostile takeovers, or as a defense, or when the hostile bidder has emerged. Now, the greatest difficulty is that in the civil law Asia, fiduciary duties is not as developed a concept as you find in the US. So which means that a lot of the transplantation of what we see in the case law in Delaware, but the US, has sometimes I think there is not necessarily a full appreciation of what fiduciary duties mean. There is also the role of the interest groups influencing the development of the takeover regulation, particularly by controlling shareholders. So if we look at Japan's, where the takeover guidelines were introduced after the Livedoor case, a lot of it actually is favored by the current business elites, the controlling shareholders. So in common law Asia, so the three jurisdictions, India, Hong Kong, and Singapore, they have transplanted the board neutrality rule. They use the regulator to resolve the disputes. In general, the courts don't decide on the takeover disputes. This is the case, especially in Hong Kong and Singapore, because they adopted the UK board neutrality rule. The reason is that there is a prohibition on litigation to be brought by the target. So other bidders can bring the litigation, but the target cannot bring the litigation. Because if the target brings the litigation, it is regarded as a takeover defense, which the board shouldn't take. The second reason why the courts generally don't decide also is because of the concentrated shareholdings. Once you use the board neutrality rule coupled with the regulators having to decide that case, it's really nothing much for the there's very little room for the to bring it to the courts by the situation, by the time that that you need a decision. So the boards have very limited ability to stop the takeover. They cannot issue the new shares, or they cannot sell material assets without having shareholder approval. So shareholders decide on the outcome of the bid. And because in any event, because of the concentrated shareholding, generally managers don't play such an important role. And again, the incumbents controlling shareholders also play an important role towards the shaping and the influencing the outcome of the regulation. The existing business elites, they are reluctant to actually change the board neutrality rule. The reason is that in any event, they control the boards. Controlling shareholders will control the boards. And the way that they would see it is that a rule that favors the shareholders would mean that that they would actually have the upper hand in a takeover. Now, there are some unintended consequences, which is that if you once you shift the power of the outcome from the board to the shareholders, you will end up actually emboldening the controlling shareholders' position. So the overall consequence, so in a separate study, but it was confined only to a single jurisdiction, which was Singapore, I found that actually when you have a mandatory bid rule coupled with a hostile takeover regulation, or the board neutrality rule that we have, it will end up reinforcing control by the controlling shareholders. So now, so in terms of where we see the direction of the takeover bids in Asia, there are several implications. So one question that arises is, to what extent why do the jurisdictions, the Asian jurisdictions, have adopted either the MBR or in the strong form of the MBR or in various aspects of it, and why have they adopted also a rule based on how the board should react in the hostile takeover? So when we look at how the development of the takeover regulation, a lot of it has to do with the importance of signaling the commitment to adopting international practice in takeover regulation. So the MBR in particular was seen as being shareholder friendly. The board neutrality rule was also seen as a rule which would again should favor the shareholders. So the shareholder-centric rule has been important and that's how many jurisdictions, when they adopted the UK version of the takeover regulation, is a signal to adopting international standards. So in particular, when we look at the regulation of hostile takeovers, it's also seen as what would be considered to be a good practice and many Asian jurisdictions will also look at the US and in adopting the we can use a rule which the board can possibly erect defenses against hostile bids, but with safeguards. And the methods that they have used is to look at how the Delaware has developed the concept of fiduciary duties, and then they adopted it into their respective jurisdictions. So all of it, I think, has to do with also a strong signaling commitment to adopting international practice in takeover regulation. But that lies the problem. When it is adopted, the jurisdictions also recognize that a wholesale adoption of either one, the US approach, or the second, which is the UK approach, is not exactly going to work very well in the jurisdiction in question. So, for instance, if you have MBR in the strongest form, this will mean that it will be very expensive for the bidders to make bids. And this will also mean that you will not have many takeovers. Likewise, for the rules and regulations surrounding hostile takeover bids, when we adopt the approach, which is the board neutrality rule, you will find that it is impossible or it's very difficult to be able to defend against hostile bids, which are not necessarily situations which they think that will be of benefit to the stakeholders. So that's why the jurisdictions then start to adapt and then they start to make changes. But what we see is that these rules, which have been in the US and the UK, were really adopted for jurisdictions with dispersed shareholdings. So when we try to interpose and transplant these rules in concentrated shareholdings, we see also some unintended consequences, including the fact that the controlling shareholders continue to have significant influence, both in terms of how they actually act, but also in terms of shaping the law and the regulation. So when we have the history of how the controlling shareholders have looked at and make changes, we can see that even in jurisdictions with concentrated shareholdings, they do not want a board neutrality rule. They are happy with they do not want the US approach. They're happy with the board neutrality rule. And the reason is that it actually will benefit them at the end of the day. So there are some, you can see the continued influence of the controlling shareholders. The question, which I think more research needs to be done, is that does it actually mean that it would cause a greater reinforcement of control within the jurisdictions? So with that, I think is the challenge of the future legal scholarship. So that concludes my presentation, and I'm happy to take any questions.
Thank you, Professor, for your presentation. If anyone has any questions, please write it on the chat or raise your hand on the Zoom meeting, and we will ask it to the professor. Meanwhile, I would like to ask you, Professor, regarding the role of judges in the decision about hostile takeovers, especially in those jurisdictions that are or that adopt a civil law legal tradition. I want to know if there has been any developed, like especially regarding fiduciary duties when facing the takeover. Not just if they have to. I would like to know if they have to. They have like a general rule, like exists in Colombia, to benefit the interest of the company. That is like a general rule, but they have a lot of action in this general rule. So they tend to benefit one shareholder, the controlling shareholder, and they really sometimes don't maximize the benefit of the company itself. So I want to know if judges have ever imposed like a sanction to one of the directors, or if they have ever like forced a sale, maybe. So like if you could elaborate a little more on those fiduciary duties of directors, especially in civil law, that would be my question.
Thank you, Daniel, for the excellent question. This is a very controversial question in the Asian jurisdictions as well. So I think I will address the question more and so in relation to the civil law Asia, because for the common law Asia, the fiduciary duties pretty much are similar to what you can see in the UK. But those are not so relevant because the courts don't determine the outcome of the takeover disputes. In this common law jurisdictions, the regulator determines the outcome of the disputes. So in civil law Asia, so what happens is that when the courts actually determine or have to, the cases are brought before the courts, they have to determine how should the fiduciary duties be applied. And these are situations where clearly there is the boards will face a conflict of interest because after the takeover, the likelihood is that the directors will no longer be directors and will lose their jobs. So how have the courts decided? I'll look at Japan and Korea. So Korea, it has they use the proper business purpose test. So is what the boards are doing, is this consistent with the proper business purpose? If it is, they have allowed for the boards to issue new shares as a takeover defense in hostile takeover. Japan is more interesting. Japan allows for the pre-bid defenses, but in the latest development, what they did was that when the directors or the board issue a poison pill, that poison pill was actually approved on the basis of the majority of the minority shareholders. So in such a case, when you already have a majority of the minority shareholders who have approved the poison pill, the courts say that yes, the board can then make that decision. So I think what it appears to be is that the courts are taking the view that the minority, the boards can make a decision which has the effect of impeding or prohibiting or making it more difficult for the hostile bid to succeed. But the shareholders must have some say, which is using the majority of the minority. Now, this is a deviation from the Delaware approach. Because when you look at the Delaware approach, there's no requirement of any shareholder approval. In fact, the reason why it is possible to have a poison pill in the US, Delaware, is that the board can just decide to issue the poison pill. So I think where we see is a somewhat of a hybrid, which is that I think full-fledged decision making by the boards, I think there's some pushback. So it's not going to be a case where the courts will say that we wholeheartedly adopt the approach in Delaware, which is that basically the board can say no, the board can issue defenses, including the poison pill, and we apply the business. We generally apply the business judgment rule. So I think this is also an area which is also ripe for development. And we're also talking about jurisdictions which don't have a long history of the case law and fiduciary duties. So I think this will be developed in the subsequent years to come. So I hope that answers your question.
Yes, thank you, Professor. I believe it's like a similar approach to what we have here. We don't have a really extensive case law regarding hostile takeovers because we don't have a really developed capital market. So we just have like some minor events of hostile takeovers. So we are just waiting to develop this case law and see what we end up adopting. We have a question in the chat. Livia is asking, hi, I would like to ask the next question. Tender offers are believed to have the potential to stimulate capital markets in jurisdiction with underdeveloped markets. Do you agree with this assertion? And what are the chances of this happening in jurisdictions like Asia or Colombia, where controlling shareholders may impede the proper implementation of these offers?
Okay, thank you for the question. So I'm not an expert on the capital markets in Colombia, so I'll confine my answer to Asia. Now, the tender offers, I think takeover offers are essential to the capital markets because you will need an ability to have a change of control. The change of control is often necessary because you want to have a mechanism to weed out inefficient companies and companies which actually can be more efficient under the new management. So I think that is essential. But you also want the shifts of control to be efficient. So certainly the question is, how do we get that balance right? So I think that is the challenge of any of the takeover regulators, as well as the people who are tasked with designing the optimal model for takeovers. The more controversial question, I think, is can takeover regulation play the part of actually having a less concentrated shareholding? So meaning, if we look at the most developed markets in the UK and the US, you have these are companies which are characterized by dispersed shareholding. So can takeover regulation actually play a role in causing more companies to have more dispersed shareholding? I think that one is more controversial. Certainly, the experience of Asia has not been in that case. Whatever takeover regulation has been adopted, we haven't actually seen more dispersion in the shareholdings. So it may be that a dispersion of the shareholdings will require other methods to effect, such as encouraging more foreign investment holdings, rather than through takeover regulation. So controlling shareholders can play an important role as well, because naturally they have interests which are not necessarily going to be the same as your minority shareholders. But so long as we have a system where if the controlling shareholders can realize value by selling out in situations where they can then invest their money somewhere else, again, that really, I think, is what takeover regulation is trying to do. Okay, so I hope I answered the first question. I think there is a second question.
Yes, there is a second question from Santiago Archila, and the following question. Do you think there is a barrier to access due to changes in regulations between jurisdictions for Western groups seeking to establish themselves in Asia, or could it become a clear division between Eastern and Western markets in the future?
Okay. I think that with what is happening in the geopolitical arena, what is likely to or may happen is going to be, I don't think it will be a clear division of the Eastern and Western markets, but I think what we will see happening would be that competition law will start to play a more important role, or much more important role than it currently is. Takeover regulation exists to facilitate the control shifts. It is closely tied to competition issues, but it doesn't determine the outcomes. So competition law is, of course, another layer, which I haven't touched on in today's lecture, but certainly takeover regulation and competition law happen hand in hand, because many of these issues were raised together. If I look at the jurisdictions in which that I have dealt with some of these issues, I think it is going to be more difficult, I think, for foreign investors to come in to actually make bids for what we call the more domestic companies. It's a number of reasons. I think it has also to do with I don't think it's a issue just on local protectionism, but I think also it's a more fundamental questions as to how important these companies will play in the capital markets. So I think maybe I'll just give an example. If we look at what is happening as a result of the pandemic, so we see that now there's a lot of importance that is being raised as to we need homegrown companies or firms that would do the manufacturing of the medical products, because we cannot be so reliant on that other jurisdictions or countries would be able to step in. So I think there's a lot that is happening, and I think it's not so much East-West divide, but I think there's a lot more concern over making sure that local companies stay within local hands. So I hope that answers the question.
Okay, great, thank you. And there is a last question, and it's from me. And is whose interests do you think are the most relevant in order to implement an MBR into a jurisdiction?
Whose interests are the most relevant for MBR? I think having an MBR will, in theory, would actually mean that the entire decision making would fall in the hands of the shareholders. So it also means that if we look at what has happened, especially after a lot of the soul searching that has been done in the UK, especially after the Kraft takeover of Cadbury, and so when we think about it, the shareholders' interests would be enhanced with the MBR, but I think the downside that the jurisdictions need to consider is that if the shareholders' interest becomes paramount and shareholders will want to sell out because they see the premium in the bid, then would it be acceptable to then have a lot of these important companies which are producing important products actually fall into foreign hands? I think that's the question the jurisdictions will have to answer for themselves. And if the answer is no, then I suspect that we'll end up in pretty much of Asia, which is that you have a lot of exemptions. So we say that we follow the MBR, but we have a lot of exemptions.
Great. Thank you so much, Professor. If there is no more questions, we're going to close the event. So thank you all so much for being part of this event organized by the Merger and Acquisitions Research Group. And thanks again to our special guest, Professor Wang, for giving this presentation on hostile takeovers regimes in Asia. And please don't forget to follow us on our social media to know what our next event is going to be, and also to read the articles we publish regarding mergers and acquisitions. And we hope that you all enjoyed this event. And thanks again to Professor Wang for being part of this event.
Thank you very much, Natalia. I would email a copy of the slides to Daniel, and you may wish to share the slides later on. Thank you.
Thank you, Professor. Thank you to everyone. Goodbye.
Thank you.